Hi, my name is Maggie Cannon, and today I'll be presenting on torts and product liability from Chapter 6 and 7, focusing mainly on the McDonald's coffee case. The area of law in which manufacturers, distributors, suppliers, and retailers are held responsible for any injuries products cause, regardless of any contractual limitations of liability. If a product or any of its component parts are defective, its manufacturer may be liable for damage under the Consumer Protection Act, CPA, or the common law of negligence. Oftentimes, courts are faced with the question, was there something wrong with the product in cases where someone's injured, or was the injury caused by the person alone? These courts use two general theories to analyze the facts surrounding the injury. Product liability, also referred to sometimes as strict products liability, and negligence. If a manufacturer fails to exercise due care to make a product safe, they can be sued for negligence by an injured user. Typically, a negligent conduct involves an action, such as hitting a pedestrian in an intersection or rear-ending another driver's vehicle. Negligent conduct may involve inaction, that is, failure to act. For example, a lifeguard who fails to rescue someone who is drowning in the pool he or she oversees may be liable for negligence. Similarly, a business owner may be liable for negligently failing to repair a hazardous condition on his or her premises that injures a customer. A claim in negligence is based on the assumption that the manufacturer owes a duty of care to all those who can responsibly be expected to make use of its product. In the case of dangerous products, such as those which, if defective, could cause extensive harm, this duty may be owed to anybody who is responsible to be affected by the defect in the product. This means that a claim in negligence is not limited by the doctrine of privity of contract, which states that only a party to a contract can sue under it. A claim may be brought by a consumer purchaser of the product, person who uses the product, or a third-party bystander who is injured by the product. The manufacturer's negligence may be a failure to take care during the manufacturing process, resulting in a particular product being defective, a failure to take care during the design of the product, including a failure to carry out sufficiently careful research, a failure to carry out effective tests, a failure to provide an effective warning of dangers, or a failure to recall a product, or to issue appropriate warnings if a danger becomes apparent after the product has been put into circulation. The McDonald's coffee case is one of the most infamous cases of negligence and frivolous lawsuits that America has seen. In 1992, Stella Liebeck purchased a coffee in a styrofoam cup from her local McDonald's in Albuquerque, New Mexico. When she went to remove the lid to add cream and sugar to the cup, the contents spilled into her lap, causing full thickness, also known as third-degree burns, over 6% of her body. She was hospitalized for 8 days, during which time she underwent skin grafting. Liebeck, who also underwent debridement treatment, sought to settle her claim for $20,000, but McDonald's refused. During discovery, McDonald's produced documents showing more than 700 claims by people burned by its coffee between 1982 and 1992. Some claims involve third-degree burns substantially similar to Liebeck's. This history documented McDonald's knowledge about the extent and nature of this hazard. Throughout the trial, there were many debates over who was at fault for the spilled coffee and the burns. The plaintiff's expert, a scholar in thermodynamics applied to human skin burns, testified that liquids at 180 degrees, which is the temperature at which Starbucks held their coffee at, will cause a full thickness burn to human skin in 2 to 7 seconds. Other testimony showed that the temperature decreases toward 155 degrees. The extent of the burn relative to the temperature decreases exponentially. Thus, if Liebeck's spill had involved coffee at 155 degrees instead of 180, the liquid would have cooled, giving her time to avoid a serious burn. However, McDonald's asserted that customers buy coffee on their way to work or home, intending to consume it there. However, the company's research showed that many customers intend to consume the coffee immediately while driving. As a result, the jury awarded Liebeck $200,000 in compensatory damages. This amount was reduced to $160,000 because of the jury found Liebeck 20% at fault in the spill. The jury also awarded Liebeck $2.7 million in punitive damages, which equals about 2 days of McDonald's coffee sales. Post-verdict investigations found that the temperature of coffee at the local Albuquerque McDonald's had dropped to 158 degrees Fahrenheit. The trial court subsequently reduced the punitive award to $480,000, or 3 times compensatory damages, even though the judge called McDonald's conduct reckless, callous, and willful. No one will ever know the final ending to this case. The parties eventually entered into a secret settlement, which has never been revealed to the public, despite the fact that this was a very public case. In the debate between whether McDonald's should be held responsible for negligence or a defective product, they should be held responsible for negligence because they had documented reports of other customers experiencing the same burns Liebeck experienced and did nothing to correct or warn against the possible hazard their coffee can hold. Their product was not defective, meaning there was nothing physically wrong with the coffee. Rather, the temperature that McDonald's in the local Albuquerque, New Mexico, was unreasonably hot. Even though it was recommended to stay this warm, other coffees at other restaurants was roughly 20 to 30 degrees cooler, leaving much smaller chances for burns. Therefore, it was the McDonald's management and lack of insight that caused these injuries, not the coffee itself. As the McDonald's should be held responsible for negligence, it can often be difficult to quantify negligence, as it can be personally discovered rather than a defective product, which is easier to observe. These qualifications are not always straightforward, especially when they include elements that we do not observe at the market price. Some examples that courts need to take into account are the actual loss suffered, the actual expenses sustained by the injured party, any loss of earnings, any loss in any future earnings due to the damaging act, the non-pecuniary loss arising from the damaging act. For example, any permanent disability, be it total or partial, and future expenses associated with or arising from the damaging act. In this case, these actual problems can be referred back to Liebeck's medical bills and history, where she had to go through skin grafting to repair the severe burns she experienced from the coffee. While the actual negligence is harder to quantify, her injuries are easy to quantify in terms of medical bills, medical expenses, and the emotional trauma that was caused from this experience. To successfully defend against a negligence suit, the defendant will try to negate one of the elements of the plaintiff's cause of action. In other words, the defendant introduces evidence that he or she did not owe a duty to the plaintiff, exercise reasonable care, did not cause the plaintiff damages, and so forth. The first kind of negligence that can be used as a defense is contributory negligence, one of the most common uses. It occurs when a plaintiff's conduct falls between a certain standard necessary for the plaintiff's protection, and this conduct cooperates with the defendant's negligence in causing harm. In plain English, this means the plaintiff most likely would have avoided injuries if he or she had not been negligent. Another kind of negligence is comparative negligence, which comes in 3 types. Pure, when a plaintiff is awarded a percentage of the damages for which the defendant is responsible. 2, modified, when a plaintiff is awarded damages only if he or her negligence is equal or less than the defendant's negligence. Or 3, slight gross. The plaintiff is awarded damages only if his or her negligence is considered slight and the defendant's negligence is gross. For example, a drunk driver strikes and seriously injures a pedestrian who failed to use a nearby crosswalk. Although it's unlikely the driver would have acted any differently had the pedestrian used the crosswalk, the driver's civil liability may be reduced due to the plaintiff's own negligence. Finally, there is an assumption of risk, which is when Plaintiff assumes the risk involved in an obviously dangerous activity, but proceeds to engage in the activity anyway. Here, one of the most infamous cases of a frivolous lawsuit is known as Pearson versus Chung, or the Pants lawsuit. Roy L. Pearson Jr., who at the time was an administrative judge in the District of Columbia in the United States, following a dispute with his dry cleaners over a lost pair of trousers, filed a lawsuit against the owners, initially demanding for $67 million of inconvenience, mental anguish, and attorney's fees for representing himself as a result of their failure, in Pearson's opinion, to live up to a, quote, satisfaction guaranteed sign that was displayed in the store. The case drew international attention when it went to trial in 2007. Pearson, as I stated before, defended himself in court and broke down in frustration in his own questioning over how much distress the lost pants gave him. In the end, the court ruled in favor of the cleaners and awarded them the money equal to that of their lawyer fees. However, their lives were never the same after experiencing such a traumatic court case. Many people have argued that the United States legal system allows for too many frivolous lawsuits. For example, this British analyst is highlighting how ridiculous some of these claims can be, such as a surfer suing another surfer for stealing his wave, and other examples like this. Other countries across the world can find these lawsuits quite ridiculous, but in the United States it's a topic of large discussion. People find that people waste thousands of dollars each year suing for causes that aren't worthy. However, the debate comes that if we start making restrictions on when one can and cannot file for a lawsuit, that those truly needing compensation for an injury or something like that won't get the help they needed, which is why this reform has never been put into action.